This case, U.S.A. versus Cope, begins when Aaron Cope was arrested for operating a commercial airplane under the influence of alcohol. The statute that makes it a crime to operate a commercial airplane while under the influence is 18 U.S.C. Section 342. The statute is broad enough to include locomotives, rail carriers of other kinds, some passenger buses, boats, and, of course, commercial passenger planes. The statute provides that it is a crime to operate or direct the operation of a commercial airplane while under the influence of alcohol or any controlled substance. And by the way, controlled substance can include some prescription medications. The statute does not define under the influence, but the phrase is commonly interpreted to mean a state of intoxication that lessens a person's normal ability for clarity and control, according to some federal courts. Also, federal law says that a person with an alcohol content of 0.10% or more shall be presumed intoxicated. That's 0.1% shall be presumed to be intoxicated. Texas law is different from federal law. Texas law defines intoxication two ways, and the first is as the loss of normal use of physical or mental faculties. For Texas law, normal use is the use that a normal person would have. So for Texas law, the standard is similar to the reasonable person standard. The second way Texas law defines intoxication is having an alcohol concentration of 0.08 or higher. The precise definition involves different math depending on whether breath, blood, or urine is tested, but all police officers and many medical professionals simply talk in terms of 0.08. Either way will work under Texas law. So even if a person has the normal use of physical or mental faculties, the person can still be legally intoxicated if their alcohol concentration is 0.08 or higher. And even if a person has an alcohol concentration below 0.08, the person can still be legally intoxicated if they have lost the normal use of physical or mental faculties. Kind of like some people get tipsy after one beer and some people don't. Even if they're not tipsy, they can still be intoxicated if they've had enough beers that their alcohol concentration is over 0.08. For further reading, see sections 49.01 through 49.06 of the Texas Penal Code. Texas has laws that specifically make it a crime to drive while intoxicated, fly while intoxicated, boat while intoxicated, be in public while intoxicated, and assemble or operate an amusement park ride while intoxicated. Also, as mentioned previously, it is a crime to direct the operation of a common air carrier while intoxicated. So conceivably, the statute, the federal statute, 18 U.S.C. 342, could be used to prosecute a dispatcher or air traffic controller. By the way, a person who flies a commercial plane while under the influence of alcohol or a controlled substance, including prescription drugs, can be prosecuted in both federal court and state court. Mr. Cope was prosecuted in federal court by the U.S. Attorney in Denver, Colorado. Regarding Mr. Cope, his story begins the day before he was arrested when he flew from Denver to Austin. The evidence was that he was the co-pilot and first officer. After arriving in Austin, the captain invited the crew to dinner, but Mr. Cope declined the offer because he said he wasn't feeling well. The next morning, the captain thought Cope had red eyes and a puffy face, so the captain thought Cope was getting sick. Then the captain, Cope, and the crew flew back to Denver without any problems. In the cockpit, the captain smelled alcohol coming from Mr. Cope. The captain said to Cope, "If you have any problem taking a breathalyzer, call off sick and get out of here." Then Cope just stared at the captain and then said, "Well, I guess I better call off sick then." The captain escorted Cope to a breath test facility in the Denver airport. I suspect this is because the captain at that point had consulted with the airline and with some other people and was told that's what he should do. In any case, he escorted Cope to a breath test facility in the airport, and the results of the first test at 10:33 a.m. were .094, and the result of the second test at 10:54 was .084. Cope elected to have a trial by judge instead of a trial by jury, and the judge found him guilty. His sentence was set at 6 months in prison and 2 years of supervision. Of course, Cope appealed his conviction. The appeal was heard by the 10th Court of Appeals, which is located in Denver. On appeal, Cope said the judge made 3 mistakes. 1. Venue was not proper in Denver. 2. The evidence of intoxication was insufficient. And 3. The judge relied too heavily on an FAA regulation and on airline policy that were stricter about alcohol consumption. We will take those complaints one by one. Venue. The trial was in Denver. Generally, a trial is supposed to take place where the crime was committed. Cope claimed there was no way he was intoxicated in Denver. The Court of Appeals said the trial could be held any place that Cope flew that day. Because he flew to Denver, Denver was permitted to be the place for the trial. And when I say any place he flew that day, I mean any place he flew over, through, landed, or took off from. Conceivably, then, the trial could have been in any federal courthouse in Austin or anywhere between Austin and Denver. Interesting question to think about. What difference would it have made if Cope were tried in Austin or some federal courthouse in New Mexico or Oklahoma? Did he think that he'd get a more fair trial? He didn't say that. There's no telling what difference he thought it would make, or if he was just taking a shot. There's no telling what difference he thought it would make, or if he was just claiming that on appeal, hoping for a new trial. If Cope were correct that venue was not proper in Denver, then he would have gotten a new trial somewhere else. Sufficiency of the evidence. The rule is that evidence is sufficient for conviction if a rational trier of fact, whether it be a judge or jury, could find guilt beyond a reasonable doubt after viewing the evidence in the way most favorable for the prosecution. This might seem harsh to a defendant, but the courts of appeals long ago decided they would not second-guess judges and juries about the facts. If the jury believes one witness but not another witness, a court of appeals will go along with that unless a rational trier of fact would never do the same. The Court of Appeals in Cope's case quoted another court saying, "Where conflicting evidence exists, we do not question the fact finder's conclusions regarding credibility of witnesses or the relative weight of evidence." And it's not just witnesses. Fact finders are allowed to pick and choose what they want to believe or not to believe with regard to medical records, tests, experts, videos, and anything else, as long as a rational trier of fact could do the same. If the judge or jury makes a decision that is irrational, then the Court of Appeals will take action. But that's rare. It is almost impossible on appeal to reverse a case for lack of evidence. If Cope convinced the Court of Appeals that the evidence was not sufficient, then Cope could go free. The district court judge said the most compelling evidence against Cope was the breath tests. But even without the breath tests, the district judge was convinced Cope had lost normal ability for clarity and control. Cope had an expert at trial to testify that the difference in the 2 breath tests demonstrated the tests were unreliable. There was a drop of .01 in 21 minutes, and a drop of .01 in 21 minutes is surprising. But the prosecutor had an expert who testified that the expert had seen bigger drops in laboratories and had read about bigger drops in scientific literature. The prosecution's theory was that Cope's body was cleaning out the alcohol, and so that explained why there was a drop, and the prosecution thought the drop wasn't too big to make the whole thing unreliable. The district judge must have agreed with the prosecutor on this. The Court of Appeals again quoted another court saying, "We are not in the position to revisit the fact finder's credibility assessments, nor are we allowed to reweigh the conflicting evidence." And remember, Federal law is different from Texas law. Under Texas law, the breath tests alone would have been enough to convict Cope because Texas says a person is automatically considered intoxicated if their alcohol concentration is above 0.08. But under federal law, unless the alcohol content is 0.10% or more, the prosecutor must have another way to prove Cope lost normal clarity and control. So Cope argued that the district judge relied on the breath test too much, and that the breath tests don't really prove loss of normal clarity or control. Cope argued that he did his job as co-pilot with no problem, and showed no outward signs of intoxication during flight except he smelled of alcohol. What probably caused Cope to lose his appeal was the 0.094 after the flight, and the opinion of an expert who testified that Cope's cognitive and psychomotor functions must have been impaired simply because of the alcohol concentration. The Court of Appeals, like any other court of appeals, would have allowed the judge or jury to believe the expert if they chose to, meaning if the judge or jury chose to. The Court of Appeals in Cope's case talked about the smell of alcohol, the puffy face, the red eyes, and the apparent fear of a breathalyzer test. But the Court of Appeals said most importantly was the 0.094 3 hours after takeoff in Austin. Federal Regulations and Company Policy. 14 CFR 91.17a provides, no person may act or attempt to act as a crew member of a civil aircraft, 1. Within 8 hours after the consumption of any alcoholic beverage, 2. While under the influence of alcohol, 3. While using any drug that affects the person's faculties in any way contrary to safety, or 4. While having an alcohol concentration of 0.04 or greater. So it appears it is a federal crime to operate a commercial common carrier while having 0.10% content in your body. It is a state crime to fly any aircraft while having a concentration of 0.08 in the body, and it is a violation of FAA rules to fly any aircraft while having an alcohol concentration of 0.04 or greater. And then the airline had an even stricter policy. And according to the case, their policy was alcohol concentration of 0.02 or greater would disqualify somebody from flying. The Court of Appeals said there was no reason to believe the district judge relied too heavily on the FAA regulations or the company policy. Mr. Cope was certainly not convicted for violating the FAA regulations or company policy. He was convicted, as the district judge said, for flying without normal clarity or control because of alcohol. So Mr. Cope's conviction was affirmed. I have been unable to find any Texas court cases in which a person was accused of flying while intoxicated. It may happen a lot more in federal court. I can't say it never happens in Texas courts, but it just may be that it happens a lot more in federal court. Also, I have not found a federal statute making it a crime to fly a private plane while intoxicated. So it might be that pilots are more careful and therefore tend to be more sober than the average driver. Anybody who is faced with a possible intoxicated crew member or airman should read all of 14 CFR 91.17, so I will post it to Moodle. If you have any questions, let me know.